All right, Chris, I'm coming at you with some more legal myths.
All right, let's do it.
A police officer who gets you for speeding must show you their radar gun.
Yeah, that's a myth. They don't have to do that, particularly out there at the scene. Now, you might be able to, in discovery of the criminal case, if you request a jury trial, you could send a motion over there to maybe see the gun or see if it's calibrated right. But he doesn't have to just roll up and show you the gun with your speed on it before he writes you a ticket.
You have 3 days to back out of any contract.
Okay, so in South Carolina, that's kind of a half myth. Generally, when you sign into a contract, you're on the hook right then and there. But there are certain types of transactions that I think our legislature has said we want to give people a cooling off period, right? So like a home equity line of credit, you have a period of time which you can back out after it. Door-to-door salesmen, I think gym memberships, and things like trade shows, if you make purchases there, you get a cooling off period. So certain types of transactions, yes, there is a 3-day cooling off period, maybe even a little longer. That does not apply to every contract in South Carolina.
Divorce courts always favor mothers in custody battles.
I don't think that's true. I think mothers probably are overall favored as far as custody. But I haven't done family law, man, in 10 years. And I gotta tell you, it's really outside my wheelhouse. I know that, the best interest of the child is on paper what the court should be doing each and every time. End of the day, that's the test. What's in the best interest of the child? Whether that's mom, dad, but certainly I think if you did a statistical analysis, you would see that mom gets primary custody a lot more than dad.
All court cases must be proven beyond a reasonable doubt.
Yeah, that's a total myth. We have 2 types of courts in South Carolina. We have criminal courts where, the state brings charges against criminal defendants to get justice on behalf of the people of South Carolina. And we have civil courts where citizens and companies have the ability to take each other to court to address wrongs between them. In the criminal realm, everything criminal has to be proven beyond a reasonable doubt. On the civil side of things, the burden of proof is usually and almost always a preponderance of the evidence. What does that mean? It's just a fancy lawyer term for more likely than not, or 50.0001%, right? And in between them, you have an intermediate standard called clear and convincing evidence. And that's where you might have some doubt, but you're firmly convinced that something is what it says it is.
So that's how you sort of settle a he said, she said kind of deal, right?
Yeah, right. I mean, he said, she said is going to come down to the believability of the witnesses, right? Because it's not the number of witnesses that counts. Let's say you've got a he said, she said, 1v1. Well, that's not a tie just because you've got 2 people saying different things. Who's full of it and who's not, right? That's what a jury decides under a preponderance of evidence standard.
Lawyers can lie to help their clients.
No, lawyers cannot misrepresent the facts as they are on the ground to help their clients. Now, lawyers have an obligation not to say certain things, but we take an oath as attorneys, and that is to be trustworthy, honest officers of the court, and that very much includes not misrepresenting facts to the court or realities to the court. So, look, we are advocates, right? We can argue, we can push a position, but when you get into the realm of outright lying, you cannot do it as a lawyer.
What are the consequences if you were to be caught in a lie?
Well, you could lose your license for one, and you could be charged criminally. Perjury, there's a lot of things that could happen. Definitely lose your law license.
All right, thank you for your perspective, Chris. It was really
Always,
enlightening.
man.